We have a very good group of speakers today. I'd like to go through those real quick and introduce them. We have Brian Brewer, who is a partner with Crowell Mooring LLP. Daniel Wolf, also a partner with Crowell Mooring. And we have Catherine Erno, who is also counsel with Crowell Mooring. Do want to be transparent, full disclosure, Crowell Mooring does provide legal services to HAI, but we also feel like they are subject matter experts right now on this topic for us. Our webinars are interactive. We do encourage you to ask questions, especially on a topic like this today. Please use the question module, not the chat module in your screen. That's usually at the bottom of the screen. Some computers might be at the top or the side. We encourage you to chat, but we pay the most attention to the question module specifically for that reason. This webinar is being recorded. We will make the link available to you or to others. We're happy to share this information. We feel like this is something the industry needs to know about, and we want to make sure that we share it and get it out right away. So with that, I would like to introduce Brian Brewer and have him come join me on camera. Brian,
Great.
thank you for joining us today. I'll let you take over.
Great. Thank you so much, Dan. And just on behalf of Crowell Mooring, thank you for the opportunity to present today. We are very passionate about your industry, and we feel like this is an important issue that the team has been following, and so really do appreciate that. What I thought I'd do is give just very quick introduction, substantive of the speakers today. As you mentioned, Dan Wolf is a DC-based partner who chairs our administrative law and regulatory practice, and as part of his practice counsels clients on OSHA compliance and enforcement. And he's also one of the Crowell lawyers representing a group of trade associations in one of the many court cases challenging the legality of ETS, and certainly we'll talk a lot about that today. So, and then joining Dan is Katie Erno, also a DC-based counsel in our labor employment group, among many other things. Katie's been a leader at Crowell's COVID response and counseling team for the last almost approximately 20 months and counting, advising clients on obligations under any number of state and local COVID orders, and currently on the various federal vaccine mandates that we'll talk about today affecting government contractors and the general industry employers as a result of executive orders and the OSHA ETS. And finally, just myself, I'm Brian Brewer. I'm the co-chair of Crowell & Mooring's corporate group and a member of our Transportation Initiative Steering Committee. My practice is transactional and commercial contracts based in nature, and this includes counseling businesses and trade associations. And as noted, we've been counseling HAI for quite a number of years. So without further ado, I'm going to turn it over to Dan and let him get on with the subject matter. Thank you.
Okay, thank you, Brian. And thank you, Dan Sweet and HAI for having us, and for all of you that are joining us. So what I am not is chair of our Zoom committee. So let me share my screen if I can pull this off. I think I can do this. I think it's within my, okay. You should, okay. I'm gonna assume you can see the screen. So thank you for having us.
Yeah, we can.
Okay, great, thanks. We are, Katie and I are going to talk about the OSHA ETS. As Dan already alluded to, it is the subject of litigation, and I will circle back to that at the end, because I know that many of you are wondering probably, well, what is it that we need to know about this now if it's currently stayed? So we'll talk about that a little bit, but let's just sort of set the scene for what's going on. And this is really the arc of 2021 and the first year of the Biden administration. As you all probably have a sense for, almost on day one, President Biden came in and announced that he was going to take what he sort of thought of as a different direction in terms of the federal government's approach toward COVID. And so he signed an initial executive order that emphasized that he was really taking aim at COVID. The first time this really became something of a regulatory in nature was end of June 2021, when OSHA, after really discussing for months between March and June, the potential for an emergency temporary standard for all of general industry, came out with a much narrower ETS that only affected those in the healthcare space. As we all know, the arc of COVID that we thought was abating by summer had a strong comeback with the Delta variant. And President Biden, using his office and his pen, took aim at that through several measures starting on September 9th, including the executive order directed at both federal employees in the executive branch and federal contractors that Brian alluded to. And then he also directed two of the executive branch agencies, OSHA and the Center for Medicaid and Medicare, which is part of HHS, through their own regulatory steps to come up with rulemaking. So OSHA came out with its emergency temporary standard, and on the same day, CMS published an interim final rule, through a different procedural mechanism, but similar, directing a COVID vaccine for all facilities that receive Medicare and Medicaid dollars. So that's where we are, and so we're going to talk about the OSHA rule in particular. And this is our roadmap. We'll talk about some basics. Katie who's a labor employment lawyer, will talk about the labor employment aspects of this. We'll cover your information and record keeping obligations. Katie will talk a little bit about how this plays with the other federal mandates. And then we'll get more into the legal issues that are beyond the ETS itself, such as the litigation. What do you do in states that have their own state plans for implementing OSHA? So the basics, this covers all employers in the United States that have 100 or more employees. And that is, for counting the 100, that's everybody. That's full-time, that's part-time, that's stay at home, that's at the office. If they're an employee in the United States, they count toward that 100. Now we'll see in a minute that doesn't necessarily mean that every employee has to comply with every aspect of this, but for purposes of determining whether you as an employer are covered, you count all of your employees. Now, what you don't count are your contractors, so you're not counting your 1099s. You're not counting agency, staffing employees, people that you pick up from like manpower agencies. Franchisors and franchisees, franchisees are separate. They're their own entities. There are, as there always is in an OSHA context, some issues with multi-employer work sites, but in general, everyone rolls up to their legal employer. So if they're not your employee, you shouldn't be counting them toward your 100, but it is all of your US employees. And then if you're at 100 or over at the start of the implementation, that means you're in forever, even if you lay off 10 employees and you're down to 90, let's say. In contrast, if you start at 90, so you're not covered now, but at some point, while the ETS is still in effect, you find yourself with 100 employees or more, at that moment that you get your 100th employee, you are automatically subject to the ETS. So that's just sort of some nuts and bolts. All employers that are covered are required to have a vaccination policy, and it can be a policy that everyone shall be vaccinated, or it can be a policy that permits testing, and I'll talk about that in a second. So what are the deadlines for vaccination? Well, you have to have the second stick in the arm if you're doing a Pfizer or Moderna regimen. All employees have to have the second stick in their arm by January 4th. Now, fully vaccinated under the ETS, to be clear, includes that two-week waiting period after the final shot. But for purposes of January 4th compliance, it just means you got to have that second shot in the arm. Obviously, if you're doing a J&J regimen, that's only one shot. So that has to be in the arm by January 4th. You are required, as in when I say you, I'm going to generally assume that a lot of people on the call are or represent employers. You have to provide employees with 4 hours of paid time to receive each primary dose. So one if it's J&J, or two if it's Moderna or Pfizer. as well as leave to cover any side effects. Other basics, testing. So if an employer doesn't want to mandate everyone gets the vaccine, then you can have a testing alternative. And that also has to be in place by January 4th. That has to be weekly testing. Tests have to be sort of the diagnostic type, so kind of thing you get if you go down to CVS. It can't be antibody count. That doesn't count. And OSHA, obviously reserves the right to come in and confirm that you're using the right form of test. Now, it doesn't require, the ETS doesn't require employers to pay for the time it takes to get tested. But, and Katie can talk about this a little bit, there may be other laws, state laws, for example, that require you to pay the employee. So the ETS, though, for itself does not. It applies to exceptions. So it applies to all employers at your workplaces unless you are a government contractor and you have a workplace that's subject to your government contractor requirements. And when I say government contractor, I mean federal contractors. And if that workplace is subject to the Executive Order 14042, which we alluded to earlier, is a separate mandate from the White House directing certain federal contractors to be vaccinated. If that's your work site, a federal contractor work site subject to 14042, then you don't have to be in compliance with the OSHA ETS. Also, if you're in a healthcare setting and you're subject to OSHA's June 2021 emergency temporary standard, that also means you are accepted from the current ETS. And then I talked earlier about employees, distinguishing between employees who count for purposes of making that threshold determination of whether you're covered as part of your 100 employees. That doesn't mean that they all have to comply. So for example, if you've got 100% remote employees, or you have employees who do go to a work site, but they work remotely and they're not around anybody else, then they don't need to be vaccinated. It's so what the ETS is aimed at folks that are actually coming to a workplace and mingling with others, obviously, because that's where you have the potential for transmission. All right, effective dates. So it took effect, at least until it was stayed. It took effect upon publication in the Federal Register on November 5th. And the deadlines that are still in place, notwithstanding the stay, are that for everything other than the vaccination, i.e. sticks and arms by January 4th, or the commencement of weekly testing and verification of testing starting on January 4th, everything else in the ETS, the deadline for compliance is December 6th. So for example, and I'll talk about this in a minute, there are certain information requirements that you have to provide for your employees. There are support requirements. There are, and these aren't heavy lifts, but they do have to be in place. Putting your policy in place on vaccination or on testing has to be in place. So there are some near-term deadlines, and this is why the litigation is relevant, because employers have good questions about, well, what the heck am I supposed to do? So that's something of a cliffhanger, but I promise you we will get to the litigation and its impacts. But those are the deadlines under the ETS itself. So let me hand the mic over to Katie to cover some more labor and employment specific issues.
Great, thanks, Dan, and it's great to be here, everybody. So the first thing I want to talk about is how you confirm your employee vaccination status. The ETS lists a variety of acceptable forms of proof in addition to the vaccine card, and they're all on this slide here. Notably, the ETS does allow for an employee attestation regarding vaccination status if the employee's vaccine card is lost or they're unable to provide proof. The attestation does have to include certain information, including the vaccine that was received, the dates, and the fact that the employee was unable to locate another proof of vaccine. But I point this out because it's more relaxed than the requirement for federal contractors under the executive order and task force guidance, which explicitly says that attestation is enough. So slightly more relaxed requirement. Another important point from the labor and employment standpoint to remember is when collecting this information, the Equal Employment Opportunity Commission, the EEOC, has made clear in its guidance that confirmation of vaccination status is a confidential medical record under the Americans with Disabilities Act, the ADA. So you need to make sure that whatever system you have in place for verifying vaccine cards also complies with the ADA. So what this means is that the information is stored confidentially, it's kept separate from the employee's personnel file, and that you're limiting access to that information to those who need to know for legitimate business reasons, like, for example, ensuring compliance with the ETS. And then additionally, to the extent that you have any third parties like customers ask about your employee vaccination status on an individual employee basis, you need to make sure you have your employees' consent before you disclose that information to avoid implicating any confidentiality or privacy issues. So for example, if you have a third-party customer who says, what's your policy regarding vaccination, you can share your policy without needing employee consent. But if a customer asks you if Joe Smith, who's going to be visiting the customer site on Monday, is vaccinated, you need that employee's consent before you can answer your customer's question. Okay, can we move on? Perfect. Next slide. So reasonable accommodations. This is a very important employment law consideration that's been on lots of employers' mind. So an employer has an obligation under federal and state discrimination laws to make reasonable accommodations for anyone who cannot be vaccinated or tested due to a legally protected reason. Title VII requires reasonable accommodations for those who have sincerely held religious beliefs, and the ADA requires accommodations for those with disabilities. At this point, I have not seen, I've been going through a lot of these lately, I haven't seen any medical reason why someone could both not be vaccinated and tested. But to the extent an employer were to get such a request and it were supported by a healthcare professional, then they would need to consider that and go through the interactive process. I have seen religious reasons why an employee could both not be vaccinated and tested. And in that case, you'd have to go through the reasonable accommodation process. Note that you're not required to grant a reasonable accommodation if it would provide or pose an undue hardship or to the company or a direct threat, meaning that the person's presence would be cause significant risk of harm to themselves or others. It can't be reduced or eliminated through a reasonable accommodation. This is a highly individualized inquiry. So you want to look at factors like the nature of the workplace, the particular job duties, the employee's proximity to others, and the percentage of other employees that you have in the workplace. Ideally, if you have someone who can't be tested or vaccinated, then you'd have them do remote work. If that's not feasible, you could explore things like change in work location to a private office, along with masking, social distancing, and maybe daily temperature screening. And you could also have a situation where it is unduly burdensome or unsafe for the workforce to grant an accommodation to a person who can't be vaccinated or tested. For example, if they're working in particularly close quarters with someone, then you could explore something like an unpaid leave as a reasonable accommodation. Next slide. Okay, cost of testing, another big question that Dan alluded to earlier. So the ETS itself does not require employers to absorb the cost of testing, but that does not end the inquiry. There are various states that have had laws that predate COVID-19 that require employers to pay for work-related medical examinations. These laws could at least arguably include COVID-19 testing. And then you also have state laws that require reimbursement for necessary business expenses, California being the most notable of those. There certainly may be arguments under different state frameworks why an employer would not have to pay under these circumstances. For example, that unless an employee has a legally protected reason for not being vaccinated, then testing is not technically required medical examination or a necessary business expense. But you need to look really carefully at the states where you operate and consult with counsel before declining to pay for testing. And then there's also the issue of anti-discrimination laws. So to the extent you have an employee who can't be vaccinated for a religious or medical reason, requiring them to absorb the cost of weekly testing could be viewed as discriminatory. The bottom line is you want to carefully craft your policies regarding payment for testing with these issues in mind. And if you decide that you're not going to pay, we also suggest directing employees to free local testing sites to the extent those exist. Next slide, please. Perfect. Okay, and the last point I want to speak to is the paid leave. So there's 2 requirements under the ETS that have to do with paid leave. The first is the 4 hours of leave per dose for employees to get vaccinated. It's important to note that you can't require employees to use sick leave or vacation leave for these 4 hours. Now, there are some states like New York, for example, that already require 4 hours of paid leave for vaccination. So to the extent you already have a policy in place specifically for vaccine leave, that's compliant, but you need to make sure you're reviewing your policies carefully and not requiring employees to use, like I said, sick leave or vacation. And then the second aspect of the paid leave is the ETS requires covered employers to provide paid sick leave to recover from side effects from the vaccine. Now there you can require employees to use any existing accrued sick leave under your current policies to the extent it's available. But if your employee doesn't have any sick leave left because they've exhausted it, then you need to provide them additional leave, paid leave for this purpose. You can't require employees to use vacation. And again, you can't require them to go into deficit, in their sick leave banks. With respect to the amount of leave, there is no amount specified in the ETS itself, but OSHA has said that generally 2 days per primary vaccination dose is compliant. And with that, I'm going to hand it back to Dan.
Thank you, Katie. All right, now this is something that we see commonly in new OSHA standards. It's sort of what I call the information requirement, and it's really the educational component that OSHA likes to push on employers, and it's no different with the ETS. So you need to make your employees aware of the policy that you're implementing and what it requires. There are some specific gives that OSHA requires, including certain documents that are listed in the slide, key things to know about COVID-19 vaccines. You're also required as employers to remind your employees about their existing rights under Section 11C of the OSHA Act to be free from retaliatory measures for engaging in protected activities. And then you also need to tell them that to the extent that they or anyone they know is making false statements, that can be criminally prosecuted. So the information requirement is, it's not a heavy lift, but it's an administrative task that's baked into the ETS, as OSHA has done in many other instances. All right, record keeping and access. Lots of questions come in about, do I need to keep the record of vaccination, or do I need to keep the testing records? And the answer is yes. And this is a function of the ETS. The ETS by its terms calls these documents medical records. Now, those of you that deal with OSHA and medical record maintenance will have a follow-up question is, does that mean I need to keep these things for 30 years? And the answer to that is no, which is why this slide refers to them. These are our words, not OSHA's words. Situational medical records, meaning as long as this ETS is in place, you need to maintain the vaccine or testing records as medical records. But when the ETS lifts, and just to clarify, an emergency temporary standard is by law only in place for 6 months, at which point it either expires or gets replaced by a permanent standard. And I can talk about that in a minute. So we're talking here about, for purposes of the ETS, a duration of at maximum 6 months. So for the course of the ETS, you need to maintain these records. And then you also need to, I should say, and this is not an ETS function, but under existing OSHA enforcement policy, adverse reactions to shots don't need to be kept as part of, if you have a record keeping requirement, you don't need to keep that, at least under OSHA's existing enforcement policy, until May of 2022. They can revisit that, of course, but that's the current enforcement policy. This is not to be confused with what Katie addressed, which is providing time to recover from adverse reactions. You simply don't have to record that an adverse reaction as a work-related injury, at least as of now. And then you need to provide under the ETS employees access to their records, and as well as OSHA when they come in to do their inspections. So that includes, your policies, and then all of your records of vaccinated, including a log. You're required under the ETS to keep a log of everyone who's been vaccinated. So that becomes an accessible record that can be that an OSHA can review, or that employees can review. All right, reporting. The ETS does require that if it's a work-related fatality, that's a COVID-related fatality, it needs to be reported pursuant to the OSHA rule, which has an exception we'll talk about in a second. And then if it's a hospitalization that is work-related for COVID, it needs to be reported. So again, those of you familiar with fatality and hospital reporting know that if you learn of well, first of all, it has to be work-related, so that's important. Had a lot of questions over the past week about, do I have to report all employee hospitalizations that are COVID-related, or all fatalities that are COVID-related just because it's an employee? The answer is no. The work-relatedness test that already exists as part of OSHA's record-keeping and reporting requirements still applies here. But the one exception that ETS brings to this that's different from your current reporting obligation is that for any other fatality, if you learn about it if it occurs within 30 days of the work-related exposure or incident, then it has to be reported. But if it occurs later in time, it becomes, OSHA says, sort of a little limitations period. If it doesn't happen within 30 days, if the fatality doesn't happen within 30 days of the work-related incident, then you don't have to report it as a fatality. Similarly, if the injury that causes, or the illness that causes the person to go to the hospital is work-related, but it occurs outside of the 24-hour period, then that no longer becomes reportable. Not so with COVID. So if you learn of a fatality that's work-related, but your employee died, say, 60 days after the infection at the workplace, that's still reportable as a workplace fatality under the ETS. Similarly, if you learn of a hospitalization for COVID that you can trace back to being work-related in the workplace, but the hospitalization didn't occur until, say, 72 hours after the exposure at the workplace, that's still reportable. Now, what I'm not going to get into, because it's highly philosophical and I still haven't figured it out, and I don't think OSHA has figured it out, is how you make that work-related analysis. So this is not I'm not going to go down that rabbit hole of what makes it work-related. I think that's a very difficult analysis to make. And I know OSHA has struggled with that from an enforcement point of view. But so point here is, if it is work-related through your separate work-relatedness analysis, then it does have to be reported if it results in a hospitalization or a fatality. All right, enough about that. Let me turn the mic back to Katie, who's going to give us a little bit on how this interrelates with some of the other federal mandates we've seen.
Great, thanks, Dan. So as Dan mentioned earlier, there are some exemptions to the ETS. We know that it doesn't apply to any workplaces that are covered by the federal contractor mandate that is issued pursuant to Executive Order 14042 and then the related task force guidance. We also know that it doesn't apply to any settings that are already covered by OSHA's June healthcare emergency temporary standard. And while if this is not explicitly in the ETS, we've had senior Biden administration officials say that it won't apply to places that are subject to the CMS interim final rule. So we know that there are those exemptions. restrictions. Now, what does that actually mean from a practical standpoint? So what it means is that you could have employees who are employees of the same employer subject to different vaccination requirements. So let's say, for example, that you're a federal contractor with over 100 employees with multiple work sites. Some are covered by the federal vaccine mandate and some are not. So for those that are covered by the federal contractor vaccine mandate, you would not have a testing option because the federal contractor vaccine mandate mandates that everyone is vaccinated unless they have a reasonable accommodation in place. But if you work at a work site for an employer and contractor employer that's not covered, then you would have the testing option under OSHA. Now, that being said, even if employees are subject to different mandates, all of those employees will count for purposes of determining whether the employee meets the 100 employee threshold for application of OSHA. So again, let's take this example where you have a contractor who's covered by the executive order who has there's two offices, each with 52 employees, one's covered, one's not. The non-covered workplace with 52 employees would still be subject to the OSHA requirements. Other difference is you may end up having employer workplaces that are subject to different obligations and policies. So for example, the federal contractor mandate requires contractors to follow CDC guidelines with respect to masking and social distancing at covered work sites, whereas the OSHA ETS does not explicitly require you to follow the CDC guidelines. It says that you have to make sure that anyone who's unvaccinated wears a mask, whereas the CDC guidelines are a bit more stringent and they do require fully vaccinated people to wear masks in areas with higher substantial community spread. So again, another potential difference there too. And then lastly, you could have employers having to provide different benefits depending on the workplace. So I talked earlier about the paid leave requirements in the OSHA ETS. There is no equivalent paid leave requirements in the federal contractor mandate, although there may still be leave laws under state law that employers would be subject to, but that could be another difference, right? Where you have employees that are at a covered work site or a work site covered by the federal mandate, not subject to paid leave, and then other work sites for the same employer are subject to the OSHA ETS that would get that leave. So for the employers who are who find themselves kind of in that position, just make sure you're very carefully looking at your workplaces and applying the rules to the right workplaces in the right way. And then lastly, I'm going to start to talk a bit about preemption and how the ETS operates with other state laws. So the OSHA ETS explicitly says that it preempts any state laws when it comes to vaccination, face coverings, and testing. So even if employees are not required to wear face coverings by state law, they still have to do so under the ETS. Employers also cannot prevent employees from voluntarily wearing face masks, regardless of their vaccination status, unless, of course, it provides doing so would create a workplace hazard. And in terms of conflicting state laws, we have seen several states pass restrictions on what employers can do when it comes to mandating vaccines. Montana and Texas are two notable examples, although even in the last couple of weeks, we've seen more and more states pass restrictions. Generally, most of these state laws can be read consistently with the OSHA ETS. There's some it's a bit trickier when it comes to the federal contractor mandate because the OSHA ETS has the test out option. But to the extent there is a conflict between the OSHA ETS and a state law, they're now or down the road, there would be preemption arguments. But then, of course, this presupposes that the OSHA ETS survives the legal challenges, which Dan is going to speak to. So with that, I'm going to hand it back to Dan.
All right. Thank you, Katie. So before we go to the litigation stuff, just want to cover quickly state plan issues. Roughly half the states have their own OSHA-approved state plans. Now, if you're in a state that's covered by federal OSHA, then obviously the federal ETS applies. In state plan states, under OSHA regulations, they have 30 days to come into compliance. Now, look, there's a practical reality to this that OSHA has a problem enforcing that. And we've seen that with the June 2021 healthcare ETS, where at least 3 states, including Arizona, have famously not adopted yet, even though we're getting close to the end of the 6 months of that ETS, an ETS of their own. So there are some, beyond the litigation challenging the ETS, there are some practical hurdles that OSHA faces. It's largely diplomatic. It's largely political. It's largely the administration leaning on governors and their state agencies to come into compliance, because it is an arduous process. Just to be candid, it's an arduous process for federal OSHA to undo, to pull back, withdraw the OSHA approval of the state plan. They can do it. It's written into the OSHA Act that they can do it, but it's very cumbersome. And when you're talking about an emergency temporary standard, which inherently by its terms is only a 6-month standard, it's getting the political machinery in place to take action against a recalcitrant state plan state. It's not readily achievable. But the point is, in state plan states, in theory, and certainly this will be true of the bulk of the states, because I think the bulk of the states will either adopt the federal standard or come up with their own that's equivalent to or more strict than the federal ETS. But there no doubt will be some who don't bring their state plan into compliance by adopting an ETS of their own. All right. Quickly, other federal guidance that's incorporated by reference into the ETS. I won't read all these off, they're on your screen, but the ETS, as OSHA tends to do with a lot of its standards, if there are other consensus standards out there that OSHA wants to adopt as its own, then it incorporates by reference, and the ETS has done so there with respect to this list of guidance, largely from the CDC, on other ways to address COVID in the workplace. Litigation. So here's 35 minutes into this webinar, you may be wondering, okay, well, what does all this mean? The day the ETS was promulgated and took effect by law on November 5th, several petitions, which were no doubt waiting to be filed, were filed, along with motions to stay. That Saturday, so one day later, the Fifth Circuit Court of Appeals, which is based in Texas and Louisiana, imposed a temporary stay, which said not taking effect. And then it ordered expedited briefing so it could get more information, hear from the federal government to see if it would, if the merits, if its first instinct about the legality of the ETS would stand up. Not a week later, November 12th, the Fifth Circuit issued a lengthier stay opinion where it really took OSHA to task and said for multiple reasons that the ETS was not lawful. So that's what's in place. And OSHA posted on its website that it would stand down on enforcement until the stay was either lifted or the ETS was resolved. Then on November 16th, well, I should say, in addition to those early filings in the Fifth Circuit, every single geographic circuit court, there's 12 of them in the United States, the federal courts of appeals, every single one of them had at least one petition for review filed. Brian made reference to my involvement in litigation, and yes, I am guilty as charged. I represent, with some colleagues, a group of trade associations challenging the ETS that was filed in the Fourth Circuit. But with all 12 circuits now in play, federal law requires that the Joint Panel on Multi-District Litigation, which usually is concerned with massive tort actions, consolidating before single district courts, it also has a federal charge in a case like this, where you have multiple petitions for review at the circuit courts, to consolidate them all in a single circuit. So it did that. And 2 days ago, it consolidated everything at the Sixth Circuit Court of Appeals, which is based in Cincinnati. Now, to those keeping score, the Sixth Circuit, like the Fifth Circuit, is overwhelmingly comes from GOP nominees, a lot of them President Trump appointees. So it is a very conservative court, much like the Fifth Circuit. Maybe not as much as the Fifth Circuit, but almost. So it's generally seen as a good landing spot if you're on the industry side that doesn't like the ETS. Now, I'll also say that this isn't, from what I've seen, it's certainly true of the petition that I am working on. This is not about the policy of getting vaccinated. This is about the authority of OSHA to do it this way and in the manner that it has done it. So there are serious legal questions that have nothing to do with whether getting a vaccine is good or bad policy. I do think this will be subject to Supreme Court review, but in the immediate near future, here's what's going to happen. Already we've seen petitions, I haven't been a part of this, but other petitioner groups have already moved the Sixth Circuit to hear the case, what's called en banc, meaning all the judges, not just a panel of 3, as would normally happen, but everybody. And that's roughly, I think, 12 or 13 judges in the Sixth Circuit. What that will do is expedite review, because in the normal course, you get a 3-judge panel, and if you don't like the result, you can seek en banc review by the full court. And if you don't get a good result at the en banc court, you can try your luck at the Supreme Court of the United States. If you start with en banc, that just gets you one step closer to the Supreme Court. I think there's a good likelihood that the Sixth Circuit will hear this en banc as a first instance, but it's not guaranteed. More importantly, I think what I'm expecting anyway is that probably, well, the Sixth Circuit has directed the United States government to file a response by next Tuesday to those motions for en banc review. I think what the United States is going to do, in addition to responding to that, and I don't know if the United States will really care if this is heard en banc or not, I think its immediate task is to get the stay lifted, because that Fifth Circuit stay, even though every case has been transferred to the Sixth Circuit, that stay carries with the case. So that stay is still in place, although now it's sort of within the jurisdiction of the Sixth Circuit. I think the United States, because this is an emergency temporary standard, it seems to me that it's consistent with their message that they're going to want to get that stay lifted. So I think they'll first ask the Sixth Circuit to lift the stay. And if the Sixth Circuit doesn't lift the stay, then they'll go to the Supreme Court. Again, for those of you keeping score, the Supreme Court these days is a solid 6-3 conservative majority, 6-3 conservative justices versus 3 more liberal justices. So it's why at the end of the day, I think there's a good chance that even if the Sixth Circuit lifts the stay, the Supreme Court will put it back in place. And I think there's a good chance, just to be candid, this isn't legal advice. This is just my instinct as an administrative law litigator. I think there's a good chance that this ETS never actually takes effect. But why are we here today talking about the ETS if that's the case? And I say that, the answer to that is because we don't know, and you don't know as employers what's going to happen. And if the stay is lifted, and if the Supreme Court doesn't reimpose a stay of its own, then this is going to have hard deadlines, like I showed you earlier, December 6th for everything but the vaccination and the testing, and then January 4th for the testing. So it's a good idea to be aware of what's in the ETS, because nothing is for certain in life, except, as we all know, death and taxes. And the other thing I'll say before we conclude is just don't take your eye off of best practices. Irrespective of the ETS, everything that people have been talking about in the OSHA world for the last 20 months still remains true. OSHA still has at its disposal the general duty clause, which basically is if there's a recognized hazard that has the potential to cause death or serious physical harm and you're not doing anything about it as an employer, then you can be cited under the general duty clause. That hasn't changed. That weapon still exists. In a Biden OSHA is likely going to be more aggressive with the general duty clause than a Trump OSHA. That's just real talk. Also, the tort duty of care. Obviously, workers' compensation takes care of the employer-employee relationship, but you may have contractors on site, or you may have family members at home who get sick. And there have been lawsuits, so I'm not making this up. There have been lawsuits that get around workers' comp because they're not strictly speaking employees. But the theory of the case is that it all relates back to a workplace, the COVID infection. So you have potential lawsuits, tort lawsuits. So all bits of guidance, whether it's from CDC or OSHA or state authorities for that matter, all of that informs best practices and the duty of care. And so irrespective of how the ETS plays out, don't take your eye off the ball in terms of what's good in terms of keeping a safe workspace for your employees. Here are some helpful resources. You'll have access to the slide deck, so I won't linger here. And now, Dan, I think it's time that we could take some questions if there are any.
I appreciate that, Dan and Katie and Brian. If you guys all want to bring your cameras on, I don't know who will be the subject matter expert for any particular question. I know you covered this a couple different points, but I just want to reiterate it because we did receive it as a question. If an individual is opposed to getting the vaccination, there are certainly options for them. That's correct? Alternatives?
Yeah, this is Katie. So under the OSHA ATS, if someone does not want to be vaccinated, then they are allowed the option of testing.
Okay, thanks. Appreciate that. Now, the ETS itself does not mention CDC guidance. Do we still need to follow the guidance, or is the ETS all we need to follow at this point?
So this goes to my last point. So CDC guidance, it's not regulatory, but you should treat it as best practice, as it applies in your workplace. Not every statement that comes out of the CDC will necessarily be applicable in your respective workplaces. But to the extent that it could be, and you don't follow the CDC guidance, you're just increasing your risk exposure to either a general duty clause citation from OSHA or a potential tort risk on the from if somebody gets sick and it spreads and that becomes actionable in a court.
Okay, we had one come in with the probability that this will continue to be stayed. What do you believe the probability is that the Safer Federal Workforce Task Force will not move forward?
Well, I have views on that, but I'm gonna let Katie go first.
All right. So they're different challenges, right? I mean, there is a challenge right now. I think we had about 20 state attorney generals who have challenged the federal contractor vaccine mandate in different states. And Texas was the first. And I know that they had the hearing on their preliminary injunction 2 days ago. I did not see, unless something has come out in the last couple hours, I haven't seen a decision on that, although it's not outside the realm of possibility. We'll see something in the next day or two, but there is not a stay in place now. I think the general view is that there are stronger arguments under, or at least maybe I shouldn't speak to this, but I think that what I've heard from many and from reading the briefs is that there are stronger arguments for the president's authority under the Procurement Act, which is quite broad, than the agency's authority under OSHA. It's really hard to predict. And of course, we may also have a situation where we have competing decisions in different states. And so we have been advising folks who are contractors to proceed as though it will be enforced until you hear otherwise. But Dan, do you have another view or other things to add to that?
Well, I don't have another view, but at the risk of sounding too professorial, I will say that although federal mandates sound like, at first blush like they're all the same, they're not. The president's authority to act under the Procurement Act through executive order presents to lawyers a different analysis. I won't weight stronger or weaker, but it presents a different analysis than does the Occupational Safety and Health Administration's ability to impose a mandate on employers and really in effect on individual employees through the statutory mechanism of the Occupational Safety and Health Act of 1970. And so we treat it as litigators both counselors and litigators who try to help translate this for clients. It's just different analyses go into how one approaches a challenge. Certainly, at a gut instinct, those that think that the federal government, as a matter of constitutional separation between, principles of federalism, between the federal government having its zone of control and states having their police powers and their traditional zones of control. Those who view it in constitutional terms might view, and again, it's a fair way to think about it. Might view this as the federal government can't do this no matter what. But when it comes to challenging this in a court of law, you have to parse that a little bit more to present the arguments that are most effective in challenging the specific mandated issue. There are different considerations that go on to the lawsuits that are already pending challenging the CMS rule that applies to facilities receiving Medicare and Medicaid funds. So different statutes require different ways of thinking about the different mandates.
Okay, we have a question from Corey. Does the panel anticipate legal challenges similar to the ETS will follow for EOs 14042 and 14043?
Yeah, so that's the same. I think that's just the same question that we just answered, right? The federal contractor vaccine mandate was issued pursuant to the EO 14042.
Okay,
Yeah,
sorry
in the
about that.
the 4.3 is federal employees, and I don't think, I could be wrong, you could probably Google and gut check me right now. I have not heard, I'm certainly not following, but I just because of the nature of our work, I haven't heard of any federal employee union challenging the president's authority as implemented through 14043. Katie, have you?
I'm not aware of any now.
So it's possible. I think that's really hard. I mean, well, I don't want to put my thumb on someone else's litigation, but I'm not aware of federal employees challenging 14043.
Okay, we have a question from Cameron, who wants to know the process for obtaining a religious exemption. Would that be something they'd just go through their HR department?
Yep, that's a great question. So we certainly recommend that as part of implementing a policy from a labor and employment standpoint, that you have a policy for reasonable accommodations for both religious and medical. And typically that's done through, when it comes to vaccine mandates, you have templates that people fill out, and then typically they're processed through the Human Resources Department.
Okay, thank you. If obviously so many people are working remote nowadays, if an unvaccinated employee who is usually 100% remote goes to the office to pick something up, does he or she still need to go through the weekly testing?
So the answer is not weekly if they're mostly remote. If they go in, OSHA says two things. First of all, they do apply a DeMinimis test for enforcement discretion. So if it's, if the facts are that you're just going in to grab something and it's say 3 a.m. and no one's around, then the answer is probably no. But if you're going into work at the office, so you're going to be interacting with others, then you need to be tested within 7 days of going in, so that you have a current test to demonstrate that you're COVID free.
Okay.
And that's a function, I should say. That's a function of that's how OSHA has portrayed this in its frequently asked questions. So that's an enforcement discretion sort of point of view.
Okay, does an employer need to report to OSHA any COVID-related hospitalization or fatality of any employee to OSHA, or only those that are work-related?
Yeah, good question, and touched on this in the talk. The work-relatedness prong still, or the analysis still exists, so it's got to be work-related. If it's not work-related, then OSHA has no jurisdiction and can't do anything about it.
Okay, we're getting tight on time. Let's go ahead and just get one or two more questions. How does OSHA intend to enforce the ETS for non-compliance?
I'll take that one too. That they're going to enforce. They said that they're going to enforce it like anything else. If they get a complaint that, for example, an employer is not either doesn't have or isn't following its vaccine or testing policy, they'll follow up on the complaint. For some larger employers, they may have programmed inspections that incorporate looking at the ETS. So that's how they say they're going to do it. Practically speaking, it will be, the easiest way for OSHA to enforce this is to go into a place of employment and say, show me your policy and show me how many employees you have, show me your vaccine log, and then they can just do an audit. But whether they have the resources to do that or not is a different question. And then if they do that and they find a violation, you'll be subject to the usual civil money penalties under the OSHA regime, which, for example, for a serious violation is, close to $14,000.
Okay, let's finish up with just a flat question. Considering the stay, do we need to comply with the ETS?
So Katie should weigh in on that too. Consult with counsel. I would advise the short strokes is what I said earlier. It's not a problem until it becomes a problem. It's stayed now, but if the stay is lifted, then it applies. And so you just want to take that into consideration. As of today, as the moment I'm actually talking, no, OSHA, it's there, but it's it's dormant. It's like a dormant gene that doesn't really manifest in any way because OSHA has said it's standing down because of the stay. But the moment that stay is lifted, if it's lifted, then OSHA is going to spring into action. So you just need to keep that in mind. Katie,
Yeah.
any wisdom to add there?
I think that's right on point. I would just add that, particularly when you think about the things that you'll have to do, like vaccine card verification, and you have to do it in a protected, in a safe way and confidential way. And often many companies who are contractors who are doing this are outsourcing this, through, specific data tools, setting those up. Like it all takes a lot more time than you would think. And so I think it's prudent to, at least take stock and have a plan in the event that this does take effect immediately, that you sort of have a game plan in mind. And then the last thing I would say is just to the duty of care point. Even if the OSHA ETS is not, is permanently stayed, it does, doesn't go into effect. Things like masking and social distancing and even testing now are becoming largely a standard of care for employers. And so you want to keep that in mind too. And obviously it depends on, there are a lot of factors specific to your workplace that would inform the workplace safety protocols that you should have, but keep that in mind as well.
Okay, appreciate it. We did hit one late question in from Mike, who was asking about options or exemptions to the mandate. Mike, I will say, please watch the video. There are options available other than the religious one you mentioned. We will do our best to have the video up on our website and on our YouTube channel tomorrow afternoon, Eastern time. There is quite a bit of information you'll want to pick up back from that. That said, Dan, Katie, and Brian, thank you so much for joining us this afternoon. Dan, if I can get the screen back, we'll get started on some wrap up in a minute. But thank you so much for taking the time today to share your information, your knowledge with our viewers. We had a significantly higher number stay with us, join and stay with us. The engagement's been very high. And so I know that the information was very important to a lot of our viewers. I know that a lot of the people will also go back and watch the recordings and they'll share those recordings with others. And so we are grateful for your time this afternoon. Thank you so much.
All right. Thanks for having us.
Thanks so much.
Happy Thanksgiving, everybody.
Thanks so much, Dan.
Bye-bye.
Okay. I want to address, first of all, coming up next week, is, as Dan said, Thanksgiving, so that's a US holiday. HAI's offices are closed on Thursday and Friday. We will not be holding a webinar next week. For those of you in the US, we wish you joyous times, peaceful times with your family. If you're not in the US and don't celebrate Thanksgiving, we ask that you be safe as always. On December 2nd, we're going to be coming back with another one of our popular "What does it take to work in my field" webinars. We're trying to do an international edition. We have right now scheduled Over the Top, a helicopter operator in New Zealand, and Ultimate Heli, who's an operator in South Africa. Both of them will be talking not only about flying, but also the maintenance options. And we're trying to get a third company in as well. They may be US, but we want to try and be as international as we possibly can. We will be sending out a questionnaire shortly. We do ask that you take just a few minutes to respond. We like to know what you're thinking about the webinars, particularly one today. Please let us know what we could do different. If you have suggestions for upcoming webinars, we'd be grateful for that as well. We always like to know what we could do better. Speaking of that, what can HAI do more for you? We've had a couple of initiatives lately that are the result of surveys that we've done. SMS programs in particular. We just got started on that. It's a great new program that you can get more information on the website by looking up SMS. But if you have other suggestions what HAI could do for you or what we could do for the industry, please let us know. The easiest way to do that is addressing an email to president@rotor.org. Jim Viola, our president and CEO, is traveling. He's at European Rotors this week. He does see all those emails and he does assign them to staff for tasking. That does conclude our webinar today. We are grateful that you took the time out of your schedule to join us. Thank you so much for doing it. Until December 2nd, we ask that you fly safe, you be safe, and we'll see you again very soon.